This case is Rose v. Rose. So we're all on the same page with that, right?
Yes, ma'am.
Okay. Please remember to stay behind the lectern and keep your voice up because we will be recording and it'll be on YouTube. Also, please don't mention, I know victims aren't relevant here, but still, don't mention any victims or any minors, please, their names. Okay, you have 15 minutes and you can reserve up to 5. What would you like to do?
Thank you, Your Honor. I'd like to reserve 5 minutes for rebuttal.
Okay, and obviously make sure you introduce yourself for the court. Thank you.
My name is Jeff Hawkins. I'm with the law firm of Slater and Zers here in Akron, and I represent the appellant, Brendan Rose. We have raised 8 assignments of error for this court to review, all of which are based on a finding of contempt against the appellant at the trial court level. Assignment of error 7 and 8 address the award of attorney fees, which were tied into the finding of contempt. The first issue is probably going to barbecue this, the Baumgart bill. Close enough? All right. My client was found in contempt of court for not paying that bill. Our argument is fairly simple. The report was never completed. The report that was provided to counsel said draft only all over it. And as such, until a final report is prepared and sent to me or my client, we don't feel he has any duty to pay that bill. The second issue for the court is the retirement accounts. My client was found in contempt of court for not timely providing his retirement accounts to opposing counsel. Our argument in that regard is that if you look at the order, which I notice that's why Judge Stevenson isn't here anymore, he actually issued the order. There was no time frame in which to complete that. There was no time frame in which to exchange the documents. There was no indication of who was to initiate the process. And by the time of the hearing on the contempt issue, all aspects of the retirement accounts had been complied with. At the trial court, obviously, Kristen Rose was the plaintiff. We would argue that it was up to her and her counsel to initiate the process. And as such, it was there for the court to find my client in contempt of court for failure to provide the retirement accounts, which, as I've indicated, he's already complied with that. The third issue is the contempt of court finding for the sale of the marital residence. The issue there was the affidavit for disbursement, which was prepared by opposing counsel, required my client to deduct one tax lien on his, that was on the house. We objected to that designation. In fact, the whole issue as to payment of unpaid taxes was litigated by a 60B motion with the trial court. We're waiting for that decision as we stand here today. Once the requirement in the affidavit was removed that my client pay the unpaid Ohio tax lien, my client signed the affidavits and the disbursements were provided accordingly, pursuant to the court order. Assignment of error number 7 and 8, as I indicated, argue error in the award of attorney fees. The main argument is, since my client shouldn't have been found in contempt of court, there should have been no award of attorney fees. Even if the award of attorney fees is appropriate, we feel that the amount of attorney fees does not reflect the required time based on a fairly simple contempt motion. That's all I have.
Thank you.
Thank you.
You may proceed.
May it please the court, opposing counsel. My name is Greg Costabile. I'm attorney for the appellee, Kristen Rose. I would surmise that part of the reason that appellant's argument was so brief this morning is because the very part of this entire matter is based on facts. The law is relatively straightforward. There's a statute, revised code statute 3105.73 that pertains to attorney fees. Although appellant, Mr. Rose, will argue that it's tied into contempt, part of it is tied into contempt, but as this court's well aware, that particular section deals specifically with the actions of a party. And the court has discretion to look, and if they feel that the actions of the party contributed to the delay of the proceedings or contributed to additional issues for the opposing party, the court has discretion to award those attorney fees. I think probably one of the main issues that are here is the standard of review. And you'll see in the appellant Brendan Rose's argument, although there's 8 assignments of error, it's really 4. And one is under an abuse of discretion, and the other is under a manifest weight of the evidence. I think particularly based on the standard of review, as well as been adopted in this specific court, and very recently, and as noted in our briefs in Russell versus Connor, as well as Morrow versus Becker, the abuse of discretion standard is the standard to be used in these particular contempt matters. Manifest weight of the evidence is not. And the abuse of discretion is present when a trial court's decision is contrary to law, unreasonable, not supported by evidence, or grossly unsound pursuant to the Vincent versus Vincent matter here in this appellate district court.
Let me ask you a question,
Sure.
because I noticed that in your briefs, and I was, fascinated with the argument, because I'm like, Anyway, the abuse of discretion, you just said it is not supported by evidence. Why is that different than weight of the evidence?
Well, the manifest weight of the evidence, as we alluded to as well, just raises the standard slightly a little bit more than abuse of discretion. So although we feel we meet both, the court has been very specific that in contempt matters, this particular court, it's an abuse of discretion standard. And so we have to look at, well, what's the standard to find somebody in contempt of court? Well, in Russell versus Connor, here in this court, the contempt test is to establish a valid order, knowledge of the order by the defendant, and a violation of that order. So we look at the 3 real issues that Brendan Rose violated. And what helps us, the roadmap that helps us, are stipulations that the parties signed on the day in August of 2021 before they went into court. One of the stipulations was, let's start with the Baum Lagron bill, is that the appellant Brendan Rose admitted that he was going to be responsible for that bill, hold the appellee Kristen Rose harmless, and indemnify her. I mean, it's a joint stipulation that he signed with counsel before we went into trial. And that's August of 2021. We're here now in March of 2024, and that still hasn't been done. And so an argument of the order wasn't over or the bill wasn't done is frankly not accurate. He's already admitted to agree to pay for it. When we look to the issue of the proceeds for the sale of the marital home, again, all we have to do is start with the joint stipulations. Joint stipulations say exactly, the home sold actually in October of 2021, very shortly before we received the decision back from the court. And it's very specific as to how it gets allocated. And what came up as is in the trial transcript, the reason that the appellant Brendan Rose didn't allow the title company to allocate the proceeds since October of 2021 is he was arguing that first a car should be paid out of it, and then maybe there's a tax-related issue, and that doesn't actually get done. The show cause motion's filed in March of 2022. It doesn't get released until August of 2022. So those are two issues right out of the box. We have an order. Defendant knew of the order. Defendant violated the order. In this case, the appellant, Brendan Rose. And on top of it, as this panel, I'm sure, has seen from the docket, the magistrate's order was never objected to by Brendan Rose. And then ultimately, when the court adopted it as its final order, the appellant, Brendan Rose, never appealed it. So we have him basically in line with the terms and conditions of the order, but just choosing not to follow it.
And when I hear your argument, I don't want to keep debating this, but it seems like you're arguing weight of the evidence. And you know, isn't there really two standards for reviewing it, contempt? One is weigh the evidence, whether there's evidence there to really support whether the person is in violation. And then abuse of discretion as to how the court handles it once it determines there's contempt, because there's any number of ways of handling it.
I understand, Your Honor. I guess I just keep referring back to the recent case in Vincent versus Vincent. And it specifically stated that the standard of review was abuse of discretion, not manifest weight of the evidence.
Okay, now.
In contempt matters, in contempt.
Right,
matters.
right.
We're talking about criminal contempt here too, because there's a 15-day
Well,
suspended jail sentence, so.
Yes, Judge.
Whenever we're talking about criminal, because contempt is that funny area. So manifest weight, well, seems that it applies.
The other thing I was going to ask you about too is, you know, I know you addressed in your briefs, but tell me again about this draft only, the argument that he didn't pay the blog run, because you said there's a agreed, you know, stipulation.
Yes.
But he's saying, you know, he's not disputing it. He's just saying, I never got a final, a bill, final bill.
Well, Your Honor, the court speaks through its docket and speaks through its transcript. There is nothing in the transcript at the trial matter that supports that argument. I mean, zero. There was evidence presented to the appellant of the bill of Von Rongren. He said it was a legitimate bill. We went on the record in August of 2021 based on the report that was created by Von Rongren. So our concern before this court is appellant, the theme in this matter is continue to prolong and not do what court orders say, and then come up with, we always hear the red herring. You come up with something that takes you away from the facts that are so prevalent and straightforward, and all of a sudden say, well, you know, I don't think it was a final bill. I mean, that's just absolutely false from his own stipulation and from the evidence that was presented. So
At
we
the
can,
contempt hearing or at the?
yeah, at the contempt hearing.
Okay.
At the contempt
So
hearing.
there was a final bill that was actually submitted?
Yes.
It
Yeah.
didn't say draft on it?
No.
Before you run out of time or anything, I'm going to ask you, the appellant mentioned the 60B motion is pending in front of the trial court now. Does that pertain to anything in here?
It doesn't, and actually, respectfully, I would ask that the court, we're not striking it from the record, but I would say that matter has absolutely nothing to do with what we are here on today. That was tried, we're waiting on a decision. Whatever happens in that matter has absolutely no effect of what we're dealing with today. Today, you know, did he, and then part of the stipulations too, which I might add, which were very, I mean, there were 2 pages, single-space stipulations, about 28 or so stipulations. And one of them specifically states that the appellant, Brendan Rose, has a master's in accounting, is a CPA, handled all of the financial issues, and anything resolving tax-related liabilities, he was going to indemnify the appellee, Kristen Rose, because he handles all the expenses. So it came out in the trial court on the show cause motion that's in the transcript, is that Mr. Rose handles all of the retirement accounts. She doesn't even have access to those accounts. So actually, for the argument of appellant to say that she was required to collect this information, again, is so abundantly and egregiously false, just looking at the transcript. He controlled all of those, and in the hearing, he actually even says to the court that he understands that she had no ability to even go in and get records. So everything was waiting on him to provide so that these retirement accounts could be allocated, and they're significant. And now we have, I mean, what has happened, we've all seen what's happened with the market up and down. I mean, this limits, I mean, we're almost 3.5 years after the, 2.5 years after the actual order. And what my client could have done with these funds, if she went to her own financial planner, is now lost. I mean, she's at the, and we don't know what's happened with those funds. So, the three real issues, again, are the real estate proceeds, and the stipulations, again, is the roadmap. Everything's a roadmap, starting with that. Provided exactly how those are going to be distributed. If you look to the exhibits that were presented in trial, you see the attempts, even prior to the show cause motion, of getting that issue done, and nothing happening. So the show cause motion had to be filed in March of 2022. And those don't get distributed until after we file in August of 22. The von Blongarm bill still hasn't been paid, even though the stipulation says he's responsible for it. And he, in trial, understood that this was the bill that was in front of him. He just didn't pay it. Finally, the retirement accounts. He had control over all these accounts. He had to prevent the information as the participant to get that ball rolling. And as you probably saw from the orders, it was very important because there was a business valuation done, that's the von Blongarm bill, of the appellant's business. And so since he was retaining the business, the magistrate and then the court appropriately took all the calculations, determined what the appellee, Kristen Rose, would receive, and it was all dependent on these accounts. So now, and at the time of trial, those accounts, there's plenty enough money in there to offset it. Now we don't even know where that is almost 3 years later. So because of these reasons, and in following with even the revised code 310573, and in adopting the abuse of discretion standard, the trial court came in, and after hearing the testimony, believed that the appellant, Brendan Rose, acted inappropriately, and as a result, did not award all of the attorney fees that were suggested, but a portion of those fees. And so we asked this court to affirm the lower court's decision, which in the end held the appellant, Brendan Rose, in contempt of court, that he be required to satisfy the outstanding von Blongarm bill, and that he immediately start the process to allow these funds, allocated funds and retirement accounts to happen, as well as paying the attorney fees of $5,730, as well as all costs associated with this matter. Thank you.
Thank you. Your rebuttal time will be less just because your first argument was so,
I will be brief here.
okay.
All right.
Thank you.
First standard of review, I did cite in my rebuttal brief the case of Easterly versus Volkman, a 2012 case out of the Ohio Supreme Court, which does indicate that if a case is tried to a judge without the benefit of a jury, the Court of Appeals can address an appeal based on the manifest weight of the evidence. The case Kim v. Kim also stands for the proposition that attorney fees can be awarded if the trial court found the litigant impinged upon the course of litigation. In reviewing the docket, there was no indication that Mr. Rose impinged the course of litigation at all. We cooperated. There were many continuances filed, none of which were filed by me or my client. So he didn't impinge the course of litigation at all. So Kim does not apply as far as the attorney fees are concerned. Again, Your Honor, as I indicated during my initial argument, as soon as the designation of payment of a 9-10-year-old tax lien was removed from the affidavit for disbursement of the proceeds, my client signed that, and the disbursements were made accordingly. And as I also indicated, the issue as to the tax payments are a pending decision on a 60B motion from the trial court. Thank you.
Thank you. Thank you both for your presentations to the court. The court will take the matter under advisement, and it is our procedure to have the court send to you our written decision when it's actually filed, but we also release on the Ohio Supreme Court website where you can see the opinions electronically. And thank you very much for everything, and enjoy the rest of your day, please.